Welcome to Saltivation. The Saltivation Show is a podcast series featuring the leading voices in salt, where we talk about the issues and strategies to help you make sense of state and local tax.
Welcome back to the second part of our episode with Leah Robinson. If you didn't get a chance to listen to the first part, check your podcast feed.
Obviously, when you find a case that you take forward, it has to have some meat and have the standing power to make it through the process, right? I mean, do you kind of think you take a case and then think, I'm going to push to settle this sooner? You're not really intending to go all the way to the mat. You're hoping just by, lawyering up, threatening to sue, they'll take a step back as a government and say, well, maybe they mean business and we can't ramrod them, right?
Yeah, I mean, I've been on both sides of that. The case that I argued in front of the Missouri Supreme Court right before COVID, $5,000 at issue. $5,000 at issue, and so there are times that the amount of money does not matter, right? There's a principle or some other reason to keep going. And then I've been involved with huge dollar numbers where the company is just like, let's see how far we can go to get a settlement. We're not going to litigate, or like we might file in litigation, but we're not actually going to go to the end. That actually is probably the much rarer in my experience. I think lots of companies go into litigation hoping to settle, but fully expecting or willing to go all the way. I've only had, a small number of situations where we went through, we started litigation knowing there's no way we were going to go to the end of litigation and we were just going to push for a settlement and we were going to try to get something and then, just end it. Like that's really been the exception. Everybody hopes to settle, right? Well, I shouldn't say that. There definitely are cases where we want an answer. We need the answer. And if we can have a settlement that also gives us a going forward answer,
yes,
fine. But you can't always get that. Sometimes the attorneys litigating the case don't want to talk about additional years. They're not in front of them. They're technically not a part of what the attorney is responsible for. Most of the time, we can bring audit back into the conversation so that if we reach a settlement, it includes how the issue would be treated by both sides going forward. But yeah, I don't know, probably a third of the cases I litigate settle and the rest go to decision.
Okay.
So I don't know how that compares to others. But
and after being at the IRS and then kind of going on the other side, going against states or going against whatever, maybe that's a bad word, going against, but representing clients in the interest against the state. How do you feel about that? Like at the IRS versus the state, that view of do we need to clarify the taxpayer or do we need to beat the taxpayer up? Like, where is the mentality, do you think?
Yeah. I don't know. I'm thinking about that. I definitely think that a lot of the people I worked directly with at the IRS thought that taxpayers were liars.
Okay.
I think that was sort of a theme. And I remember when I announced that I was leaving to go to private practice, I remember somebody who is now pretty senior in the IRS Office of Chief Counsel, like coming to me and commenting about I was going to the dark side. Only partly joking. I mean, I loved Chief Counsel and I'm still close with a number of people there. Multiple people from Chief Counsel were in my wedding, which happened years after I left the Chief Counsel. So I'm incredibly fond of my time there. That being said, there was definitely that mentality.
Okay.
On the state side, I don't know that I see that mentality as bluntly, but I also don't know that they would say to me, right, I think your client is a cheat. I think there's just general skepticism at the audit level, which is appropriate. But often in matters I'm involved in, we go above the audit level and we're dealing with senior audit management. And I think that for the most part, senior audit management are very smart, very practical people who seem to want to get to the right answer. Whether that always trickles down is another question. I think auditors are looking to find adjustments. That's their job. I don't fault them for it. That's their job. Sometimes I wish they would be more open-minded about the types of evidence or like the documents we provide or the proxies, like, oh, this document doesn't exist, but we have this other thing. Often that other thing is just rejected flat out because it's not what they're hoping to see. But I'm often dealing with more senior people and, I think most of the more senior people I deal with really are are trying, and often succeeding and trying to get to the right answer, do the right thing.
Because you're only going to get cases where that's really there's a line that's not black and white, or we wouldn't take it forward. Because I feel like sometimes auditors misclassify the character of a business, right? Are you a service provider? Are you software? What are you? Right? In the digital space, in the real world space. And no, we just treat you as, because if you deal with tangible personal property, I just had a conversation with a city auditor yesterday. If you sell tangible personal property like a maintenance person and it involves tangible personal property, you're a retailer. I'm like, I'm not a retailer. I'm out there wrenching on things, and I might have a screw and a bolt and a knife, and I might have to wire something, but I'm not a retailer. I'm not selling them the bolts. I mean, yes, they're going to get left there because I needed to fix the part. But it's just, to me, I thought, really, you're going to put it in that category and then say basically all services are subject to sales tax, right? So that feels like an overreaching in that space. And I think definitely, you're working in the digital economy, and there's a lot of, in my opinion, challenges working through what the heck you're selling. Because even within software, like you were saying, that client, they're adding all kinds of stuff to make the software more robust. And they don't tell the customer that. They just add to it because it's SaaS. And then it has all these, bells and whistles within it that make it higher functioning. And so really...
And then you look at their website, right? You look at the company's website. Oh, the website. How they're advertising it. Or more on the corporate tax side, you look at the company's 10K and how they describe themselves. And I feel like every auditor is going to the website and printing off the descriptions. And, it's... And I get it. The business folks at a company want to describe themselves a certain way, right? They want to appeal to their client base, but that doesn't mean that that's what the technology really is doing.
Right.
And, I think that's like a very constant conversation with auditors is, sure, the website says blah, blah, blah. But if we look at how the product actually functions, what it does, from a technology point of view, they're not delivering software, just in the SaaS space, right? Like in New York, in order for there to be a lease of tangible personal property, which is how the state classifies remote access software. They say it's constructive possession of TPP. Well, what's the TPP? The TPP is the source code.
Where is it? Right.
Right. I've always said, like, at least New York's position, which a few other states adopt as well, is very schizophrenic. They, for purposes of taxability, they treat it like tangible personal property. But then for the sourcing, they treat it like a service. Right? And New York law doesn't work that way. It's either TPP, where delivered, or a service, which is more like a benefit received concept. But if it's TPP, if the actual TPP is the source code, those zeros and ones, where is it? If the software is not actually delivered, it's sitting on a server wherever the company's server is. And if that's not in New York, then sure, it might fall into your taxable category, but you don't get the sourcing. Now, New York, on the other hand, says, well, it's software, it's zeros and ones, which we consider TPP, but since I can see it on my screen, then I'm controlling it from here. I think the technology behind that sort of falls apart.
Yep.
And I think taxpayers have been very successful in New York matters on this when they do challenge it. There's, I think a very high success rate in challenging it. The problem is you have lots of folks who don't challenge it. You have lots of vendors who say, push down to the customer, right? So I'm just going to collect. There's enough guidance that I can point to show why it might be taxable. So I'm going to collect. And then the customers are like, but we don't think this is taxable. But maybe their total charge, their total tax is $5,000, $10,000. Right? Are we going to litigate over $5,000, $10,000?
No,
probably not. Right. And so, or are they not, even if it's more money, are they going to file a refund claim, but bring more attention to maybe some of their own, tax profile? Like, I think, so it's unfortunately, I think, one of those gotchas where the state, and not just New York, a number of states have a lot of guidance out there that's enough to cause, most of those smart charts, right? You go to any research engine, you do a smart chart, and you find SaaS is taxable in all these different states.
Oh, yeah.
But if you then go into some of those states and look at court decisions, you see a different answer. And so it's a mishmash, and whether or not it's worth taking on the risk is a discussion to have, right? Sometimes if you're just going to push it out to your customers, why take on the risk? On the other hand, if the the courts have signaled an answer different than what the departments have signaled, maybe you should challenge it.
Yeah. No, I just feel like there is a lot of overreaching in this space, and it's been, and even like healthy, like information as a service is a great one. Storage, Amazon Web Services. You're paying for security, you're paying for redundancy, you're paying for oversight. I mean, there's a lot that is rolled up in your ability to store stuff on the internet. It's not just storage of a sled or a slide or whatever they're called, the computer power drive. And that site is somewhere, right? And it's transmitted all over the place. But there's all kinds of things wrapped in that service that don't almost have a situs. So I think it's really hard to source some of this, just besides bill to, because ship to is not really anywhere anymore. So I think that is really an area that is challenging to tax.
I agree completely. But the problem with ship to is you still see a lot of old-fashioned invoices.
Oh, yes.
Right? The invoice still has a bill to box.
That's right, it does.
Box. And even when it's something that is very clearly electronically delivered or remotely accessed, meaning no delivery, you often still see information in the ship to. And it's like legacy invoicing software that puts information in there. And now you're fighting it, right? You're fighting your own documents because they have a ship to listed.
That's right.
Like, we're litigating this issue for one of the big insurance companies in New Jersey right now on information services and software. And, there's a darn ship to, and it'll say lower on the invoice, electronically delivered, but there's a ship to.
Well, and then that other thing is there's shared services centers in New York. So bills are processed there, or billed in Minnesota, or whatever, Texas. I mean, you have situations where there's somebody going through all the AP, and they're just processing invoices. And then it's being used across an IBM multinational company, right? So there's shared services centers in New York. Well, so of course it's a bill to there, but they're not getting shipped it if you want to ship it. So that is a real problem to overtax in New York when you're billing hundreds of thousands of dollars of license fees to a shared service center that's just paying the bill, so that all the people at the company can have access to these different products.
And I think that's an area where there's probably a lot of refund opportunity for companies, both software and information services sourcing. And we're seeing more and more cases where the courts are agreeing that you get to source those services, right? There was a recent Massachusetts case on software. There's other states' guidance that, really mean, if you're buying a lot of software, remote software, or if you're buying a lot of information service that is, delivered electronically or accessed electronically, it's worth taking a look. Now, I am not a huge fan of reverse audits. I've seen reverse audits come back.
Me neither. Yep.
Right. But on a thoughtful, item by item basis, there certainly are times when it makes sense to go back and look and see, did you assign your information service 100% to a state that taxes information services because that was the billing or the shipping address?
Right.
And in fact, your users are elsewhere.
That's right.
And sometimes it's just good to keep that in your back pocket for when you have an audit to raise it as,
as some kind of an arbitrage.
Well, and then what we have conversations with our clients about is the opposite, right? It's like, okay, well, if we're pulling this specific invoice out of New York, it's like, well, remember, there's like this handover here that you need to put into New York. They're like, oh yeah. So we're just going to ignore it all the way because at some point it might wash. Sometimes it won't, but then it's like, yeah, we can't just pull things out without thinking of the opposite and putting things back in.
Yeah, no, absolutely. And but it's sometimes it's worth checking because that other state might not tax it.
That's right.
Or that other state might have guidance that says we assign this to billing address. Right. Well, then you're fine in that state because the billing address was somewhere else. But in some other state where it's not clear it should be billing address, but rather where the users are, right, then it does make sense because you're not going to just move it from one state taxability to another state. You have a strong basis in the other state to say, oh, your rules say we assign it somewhere else. right? We're not playing games here. We're just following your rules. But this other state says we can look to actual use. Sometimes it doesn't always work out that way.
Right.
Yeah. Well, and we've kind of been talking about this all along is kind of this like idea of overreaching and whatnot. But I think what we wanted to kind of hear from you, Leah, is if you see and where you see kind of government's overreaching kind of beyond what may be allowable under the Constitution. And if, you can speak to some of those items, maybe you don't agree with that statement, from some of the constitutional limitations that there may be some like, we're getting real close to like, this just isn't allowed by, the Constitution and whatnot.
Yeah. I mean, I think post Wayfair, there's been an assumption that economic nexus is the end of the story, right? If you have economic nexus, you're taxable for income tax purposes, for sales tax purposes. And I don't know that that's actually been answered yet, at least in the income tax realm. But there's another side to Wayfair that I think doesn't get that much attention. And that is, what did Wayfair do? Right. Wayfair basically told us that Quill is not good law. And what did Quill say? Quill said physical presence was enough. Right. So if we get rid of that, if we say kill Quill, right? So that chant that we all remember from a few years ago, if we say Quill was killed, that means that the concept that physical presence is enough is gone. Where does that leave us, right? If Quill is no longer good law, what's left as good law? And I'll tell a little story and then I'll say what I think is left as good law. A number of years ago, this case came out in New Jersey called Telebrite. And the decision, and this is while Quill was still good law, the decision in the issue in Telebrite was the company had one income tax case, one work from home employee who was a tech person. And the state said that one full-time employee in the state is physical presence and therefore you have nexus. And that's what the court agreed on. And a few months after the case came out, I was presenting with a person who was my partner. We were presenting together at some event talking, just case updates. And Telebrite was on my list of cases to give the update on. And I get up there and I say, a lot of people were surprised by this decision, but like, I think it's the right answer, right? Physical presence doesn't, one full-time employee, that's physical presence. Like, why are people so surprised by this case? And my partner who I'm presenting with is like, Leah, are you crazy? That case is completely wrong. And I'm like, what? Physical presence? And she's like, no, the person was back office. The person was not doing things to solicit clients, to establish and maintain a market. And so their presence shouldn't have counted. And I was like, but physical presence, right? Like I am a firm believer in physical presence. I think Telebrite was right. So she and I are having this whole argument, kind of like a friendly argument, but kind of forgetting that we have an audience and because we're partners at the same firm and we're arguing and it was all in good fun. And afterwards people were like, oh, that was the best part. And I'm like, it was embarrassing that my partner and I are arguing with each other. And they're like, no, that was the best part. At the time, I thought I was absolutely right because of Quill. But now that I look back, now that Quill is gone, I look back and I realize that she was right. And I think the answer is without Quill, physical presence isn't enough. What do we do if we cross Quill? If we think about the list of Supreme Court cases dealing with nexus, if we cross Quill out, right? Quill is gone. Where do we go to next for determining what an appropriate nexus standard is? Because Wayfair didn't, right? Wayfair remanded, right? It killed Quill, but it remanded on whether or not that test was a good test, and then it settled. So if we look at what the Supreme Court has actually said, next in line, we look to Scripto and Tyler Pipe, right? Scripto and Tyler Pipe were two separate cases that both supported the concept that it doesn't matter if you have your own in-state physical presence or somebody else in the state. If there is an in-state body establishing and maintaining your market, that is nexus. So fast forward now, right? Think about that, the Telebrite facts. You have one person in the state and all they're doing is back office IT. Quill tells us that their physical presence is not relevant. So we're left with Tyler, Pipe, and Scripto. Is that one person who's just doing IT work establishing and maintaining your in-state market? And I think under those facts, the answers are pretty clear. No, that yes, you have a physical presence, but we don't care about that. But what you don't have is somebody establishing and maintaining your in-state market. And I think this is sort of the next generation of Nexus challenge that we should expect to see. And that is where you have a physical presence, but that physical presence is not related to establishing and maintaining your in-state market.
Yeah, but is that back office development person creating your website that is putting cookies on someone's computer, that is constantly pushing content to people that brings them to their website and is keeping that person perpetually buying? So by, going here to here, is it establishing a market? So,
but then is it establishing a market in the state in which the person is domiciled? That's the bigger issue to me. Like, what really is happening is you're open for business. And so you're going to sell to anybody if you can get it to them. And it doesn't matter where you are because the boundaries of, your location is no longer your limits. So I think that's the challenge of, is the intention behind even that marketing guy in the state really at that particular state? No.
Right.
You
can have a marketing person in a state who's assigned to a different region.
You're just marketing. I mean, you're marketing to anybody who buy from you and you have the ability to sell to them. So I do think that's a problem.
Yeah. So I think there's a lot of overreach there. We're litigating an issue in a southern state where we initially raised exactly this argument. They had, 1 to 3 in-state people who were marketing people, but they were not assigned to marketing for that state. They both had different, or they were there at different times, but they had different regions. And so when we initially took this particular matter to court, we raised exactly this argument. In fact, we had finished our petition a few days before Wayfair came out, but it wasn't due yet. And then Wayfair came out and we added this argument. We're like, what? Like, Quill's gone. So now, we weren't even going to challenge Nexus because of Quill, and we had 1 to 2 people in the state or 1 to 3 people in the state. So we weren't going to challenge Nexus. Wayfair comes out and we threw in a challenge to Nexus saying under Tyler, Pipe, and Scripto, these people weren't establishing and maintaining the in-state market in that particular state. And we ended up pulling a Nexus argument from that matter because we think it distracts from the primary issue. But I do think it's going to be litigated. I actually was speaking at the MTC annual conference the year Wayfair came out. So Wayfair came out in
June 20th, 2018.
Okay. I spoke at the MTC conference in August and in front of a room that is almost all government officials. I make this argument. I say, look, I get it. Wayfair is great for you guys, but there's also an angle that, maybe some of our, company physical presence doesn't give Nexus, and there has to be actual
purposeful availment, not just open for business, sending something via FedEx or via the internet.
Yeah. So I'm saying this in front of a room of almost all government folk, and this was actually reported. This little argument and conversation that I'm about to say was reported by State Tax News because they were there. So I say this. And there's, a very well-known government person from a Northeast state sitting there shaking his head no. And a very well-known government person from a Southern state gets, we get into an argument and he's disagreeing with me. And that's sort of the public conversation. But then at the same conference, as I'm having coffee, somebody from a different state comes by and says, you might be onto something. And then at dinner that night, another government official actually invited me to fly out to their state and meet with their senior management to talk about issues like this so they could think about them. So even though a lot of state government folks' initial reaction to what I just said is likely to be absolutely not. We've got you if you have a physical presence, and we've got you
if you have economic presence
to our state.
Yep.
I think some of them take a step back and think not what they want the answer to be, but if we look at what's left as the Supreme Court has interpreted due process and commerce clause, if we think about what's left, right? Tyler, Pipe, Scripto are still good law. And those cases did not extend Nexus except where there was the establishing and maintaining of an in-state
market.
Now, I think to Meredith's point, or where her question was going, is can't you do that through technology?
Mm-hmm.
And now it's done. And I do think that that's a difficult area that the courts haven't got into yet. Cookie nexus, honestly, I have less of a problem with cookie nexus than with the South Dakota Wayfair standard. I would rather see cookie nexus as the standard.
Because I Googled you. So I'm in state. You reached out to me. That's an affirmation that we've connected, not just this random, I got stuff, right? Oh,
well,
interesting.
So I mean, for me, it's a little bit more of...
because you're tracking me and marketing to me.
Well, no, so I still think physical presence is an easier standard. And cookies, even though they're intangibles, they still take up space, right? It's taking my hard drive, right, has a limited amount of space. So even things that are intangible, like software, they still take up space on a server, on a hard drive, et cetera. So I have less, that's my approach to things. Let's get to the technology. Not how we think things work, because what do we know? Right. Let's talk to the IT folks and understand how the technology actually works. And so, cookies are data files that are saved in your computer. So I have less of a concern with something like cookie nexus versus I'm making sales to customers in a state. Right? My website's not limited to that state. Anybody in the US or maybe anybody in the world can access my website. That shouldn't, in my mind, pull me into a state. But if I have decided to set up my website in a way that it will seek to put cookies on your website, I think I have
taken that next step. Right. You've taken that next step to really go do that person. Yeah.
And maybe that's still insubstantial, right? Or, maybe that's not enough. Mm-hmm. But in my mind, if there's a spectrum, right? If Nexus is a spectrum, cookies to me are closer to Nexus than just the way, the South Dakota standard of having sales into a state. To me, that's farther afield from what the right answer should be. And, we don't have a right answer. The Supreme Court absolutely knocked Quill out of the running, but it didn't say that the South Dakota test was itself the right answer. It remanded. And then that issue didn't go back up. So, but what they have decided was Tyler Pipe, was Scripto. And so, I think that there's more.
The purposeful availment's still out there, possibly. Yeah, I've thought about that too. Well, I have clients that say to me, we just don't want to sell to these states anymore. I'm like, you're open for business. How are you going to do that? How are you going to tell your website, if you're in this state, you're not getting anything? Technologically, even, it's sort of an interesting issue because people do get frustrated. And then there's that whole thing of we're already collecting in 15 states. What's another 2? I mean, at some point you put the system in place to manage the compliance. It doesn't really kill you to add a couple more states. You do get some volume, benefits, critical mass. So it is really an interesting push-pull. So,
although the interesting thing about the compliance effort, right? If you look at all the state briefs that were filed as amicus in Wayfair, the states, and not every state, again, I'm being a little too general here, but a number of states signed on to briefs that said compliance is easy, right?
I know, right?
There's these cheap software things you get, right? But then take a step back, and then the states were saying, oh, wait a minute, we can't start applying Wayfair yet, the South Dakota case yet, because we need to fix our technology. It's going to take us. Right?
We can't ingest it. No, we can't ingest the data. Colorado was location-based reporting. They couldn't collect on behalf of all these other cities. They were one only. And then the Department of Revenue was saying to us, just pick the ones you need. I'm like, you're kidding me. I don't know what I need. I'm a remote seller. I could need this one and that one. Next month, not a need at all. Of course, I need to put the money in the right bucket. So I have to open them all. So it's interesting.
So I don't fault the states for wanting Quill to fall, and I don't fault the states for supporting a South Dakota standard. I mean, I don't personally agree with it, but I get it, right? Raise revenue. But I do fault them for signing onto briefs that talk about how easy
it is.
Because it's just not it to me. As somebody who's worked in this area, and probably half the work I do is sales tax. There's nothing easy. We litigate sales tax all the time. We litigate taxability. We litigate it under streamline. We litigate it in non-streamlined states. It's not clear. And the states put a ton of effort into advisory opinions. And so just the taxability determinations aren't easy. The compliance, the technology of compliance is not easy. So I've always been very upset at how easy it was, like how it was presented to the Supreme Court in amicus briefs as simple, straightforward. And
by someone who's never probably filed a return.
Don't even go to the filings of the returns. Like some states you can't even fill out the form to get the license. Like we couldn't get a New York State license because their online system, which is the only way to get a sales tax in New York, has to have two responsible parties. But this woman is a sole proprietor operating as an LP that is her and a business, but the other responsible party is not a human. So we can't officially get our license. So it's like, the systems aren't even set up to even like give you the chance to even send you money.
Or like foreign companies who
they don't have social security numbers.
Right. Social security numbers. Yep.
Yeah. You're like, sorry, we want your foreign money, but we can't take it because you don't have the right numbers. Yeah, it's funny.
Yeah, it's sales tax is always going to be complicated because you don't tax everything, right? Yeah. There's taxable items and then exempt items and taxable services.
Taxable people and non-taxable people.
Right, so it's always going to be complicated, and that's fine, right? Like that's not like, okay, it's going to be complicated, but to undervalue how complicated it is, to me, is just too results driven, and that's not what I think departments are supposed to do, right? Change your laws. Do things the right way, be above board, admit, hey, this is going to be complicated to do, but we think there's appropriate reasons to do it, right? I would have preferred that message sent to the Supreme Court. Like, yes, this will cost companies a lot of money to come into compliance with, and it will cost us states a lot of money to change our systems to accommodate, but we think there are reasons to do it anyway, right? That would have been my message. Yeah. But, the change I'd like to see in the sales tax world is I'd like to see combined reporting as an option, right? Like,
you mean for all entities multi-owned and not FEIN driven?
Yeah. So like in the income tax world, we have a combined report, and in some states you determine the separate taxable income of each entity and you mush them all together, and it's one report that gets filed. Right. It's one signature. Some of them require separate signatures, but it's one audit, etc. Why don't we have that on the sales tax world, right? You have a corporate group with tons of different entities that are each, I talked to some tax directors at companies who are signing hundreds of returns. Why not have combined reporting for sales tax? Yeah. I don't think it would impact the total dollars at all. It would just be it would ease compliance, and it would ease the state's, their intake of the returns, their audit, et cetera. I'd really like to see a movement be, behind that. I've talked to a few directors, like tax Department of Revenue tax directors, about it, and they're like, "Oh, that sounds like a good idea. Like, we should do that." And then the conversation never goes anywhere else.
Right, can't do it. We're set up an old, antiquated way, and we just can't pivot from that.
But I would like, I don't know. I think like what are things that can make taxpayers' lives a little bit easier?
Yes,
that don't cost state revenue, and in fact maybe save the state some money as well. Yeah. Combined reporting on sales tax would be at the top of my list for that.
Yeah.
Yeah. Well, and Leah, I think that's the kind of perfect noodle to let us, sit on as we wrap up this conversation. We had a long list of things we wanted to talk to you about, and we got to 1.5 of them. So we really appreciate kind of this really interesting conversation. Some, Judy and I are not litigators, so some of that insight. We really appreciate your time. So thank you so much for being here. And that's another episode of Saltivation. Until next time.
This podcast is for educational purposes only and is not intended, nor should it be relied upon as legal, tax, accounting, or investment advice. You should consult with a competent professional to discuss specifics of your situation and the applicability of the information presented.